Now back to the show. This is The Law Show on CL 650.
I'm Zach Spencer, and welcome back. We're talking about what's very important. It may be not important to you because you will be gone, but to your family members and all the grief that happens around estate planning. And we're talking with John Lakes and John White from LakesWhyteLLP in North Vancouver about the basic rules of a will and how it should absolutely be prepared properly, because that's when you get into trouble. But if you talk to 10 different families and you said, what is the one thing that has torn a family apart more, I would suggest it comes around money and wills. And I've seen that in my own family, that there are uncles that don't speak to each other anymore. So getting this right before you go is important, because that's when the hard feelings can really happen, right? Is that what you found as well? Is this is what this is not doing it right? It's what rips families apart.
Well, let's put it this way. I mean, if you care enough about your descendants and your family to write a will in the first place, then you should care enough to do it properly.
Mm-hmm.
And for the same reasons.
John?
Yes.
Yeah. All right. Now, we talked about executors before the break, and now trustee. So for the layperson, what's the difference? Because to me, they kind of sound similar.
Well, an executor usually has their work finished within 3 years. However, in a will, you may create a trust to hold funds over a longer period of time. So the most common trusts are for children under a certain age, disabled adults or adults with some difficulties, and second marriages. So you may have a chunk of funds that are kept aside for either till the youngest child is 25 or his second spouse dies, and therefore their job is different, is it? Because they're going to maybe pay out a lot of people money, but they may hold back 25% for the next 20 years. Now, the person who's a trustee can be the same person executor, because the job overlaps. But this is really where it's very important when you determine who's going to be around. So, for example, let's say we have a situation, you've got a disabled son, Liam, who'll be disabled for his whole life. He's 45. Your daughter is 60, so you're going to name her a trustee for Liam. However, there's a very good chance that Karen will predecease Liam. So, you've got a granddaughter, Hannah, who's maybe 28. She's a bit of a partier right now, but you might have to just have faith that once Karen has passed on, that Hannah is willing to take in and take over and help look after Liam, because you don't really want the government to take over the trust. So it's so if an executor, you may be looking at just people your own age. However, you're creating a trust, depending on what the trust is for, it's the same thing. So second of all, if it's like a second spouse, a lot of times when people get married in later periods of time, they agree that they'll keep their assets separate. But let's say the house is kept separate, kept for the second spouse, maybe some monies are kept for the second spouse. You don't appoint your son, who hates your second spouse, to be her trustee, because he's just not going to act in a judicial fashion. So it's the trustee is a very important thing to consider, because it may never come in play, but it may do. And if you've got a child who's an adult disabled or has got some mental health issues, you've got to have somebody who's sympathetic too. I mean, people with mental health problems is getting much larger, and sometimes they're called personality disorders or whatever. And some siblings are not very sympathetic towards that child. You don't put that sibling in charge of the trust, and on the other hand, you don't put the sibling who just every time the disabled child bullies him for more money says yes as well. So to manage a trust is actually a lot of work, and you have to look at why the trust is there, because you have to account to people. You have to account to the beneficiary. Sometimes you have to account to the public guardian trustee as well. So it's probably the thought of a trustee is a really important.
I've got a scenario for you. So you have 3 children, and one of them is a drug user, sort of, on the fringes of society. Could you put their inheritance in a trust just because they're not at a place where they should be using that money? Or can you say this person's going to look after this money until they're at a point where they can? Is that possible?
I generally would put them in a trust, because the problem is if you don't put the monies in the trust and all of a sudden they have a whole lot of money,
that's what I'm worried about.
It's going to go very quickly. but you may then you have a discussion with the lawyer. Well, is the money's going to be used for rehab? Is and
Just basic living expenses.
and so again, your one child may not have may have had it, doesn't want to have anything more to do with the kid, looks at parents being enablers, but somebody else may be willing to try rehab one more time. I mean, it's.
But what I'm getting at is you don't when you have a will and you have 3 children, it doesn't have to be divided. And
No.
and as you mentioned, within 3 years the will is finalized.
Yeah.
You can carve off some of that for a trust.
Well, I've had times where, for example, someone puts a trust for their son because he's going through the marriage hell, and so they want to, and the son's quite happy about the trust because they know that money can't be part of, not available, or else. Sometimes if a son's going bankrupt or something. I mean, there are, lots of reasons for trusts. I mean, the CRA's just changed some rules now, which I mean, the whole philosophy, a lot of CRA issues is trying to make things simpler. Sometimes people are trying to create these elaborate trusts to avoid taxes or delay taxes.
Well, you heard about trust fund babies, right? Like kids that never really work, they just live off the trust.
Yeah. So if you're doing it primarily for tax reasons, you need to talk to an accountant because the problem with those sort of trusts could disappear next year by the change of legislation.
Really?
But the trust for people with mental health issues. I mean, one of the things is if you've got a child who's on BC disability program, it used to be in the old days, people would say, "Oh, I don't want to leave Mary anything because I don't want it to affect her disability." Well, the government will sue on behalf of that child. So if somebody's on a disability, you have to take that in consideration. You have to create a trust. But the problem is the rules that they allow for trust funds for people today may be totally different 5 years from then. So therefore, you need a trustee who actually can act flexible and be able to be on top of things. And
Can you use a trust to delay the child getting money? Like, for example, you don't want them to inherit $500,000 when they're 21.
Yeah, no, lots of people do that.
And so you keep it in a trust till they're 30 or something.
Well, yeah, I mean, just by definition, I mean, if the child is 7, you're going to put the money in a trust until at least that child comes of age. So what you're talking about is just extending that principle a few years into the future to the age of 30. Happens all the time.
Okay.
Or else you can do
Is that the best way to ensure that they don't get all the money too
well,
quickly?
You see, it depends on the kids. I had clients of mine who stopped doing their will. They had 3 kids. The first 2 kids were very responsible, and they had everything when the youngest child was 25. However, the 3rd child came along, very charming person. Then they raised it to 30, 35, finally to 40, and they thought, you know what? They blow it 40, so be it. But every family's different, and that's the other theme all the way through. Is even if you have a will, you have to review the will from time to time to see circumstances change. So, for example, you could have a child who's doing fantastic in 2nd year medical school or something, and they look fantastic, and then they go skiing, have head injury, and all of a sudden you've got a totally different situation.
Yeah, needs to be cared for. Now, what about gifts inside a will?
Okay, can I just talk a little bit more just about the executor job?
Yeah, absolutely, yeah.
Okay, so one of the things that when you're an executor and a trustee, a couple of things is you have to deal with the person's assets, and most importantly, you got to get an accountant right away because CRA comes first. And if you don't deal with the CRA, then your problem. The CRA problem becomes your problem.
Well, what are the 2 things that are guaranteed in life?
Taxes
and death.
So
right, we're already talking about the one, and now we're talking about the other one too.
So the thing is, you got and when you appoint someone as executive trustee, they can actually charge a fee up to 5%, and it is taxable. If you decide to use a trust company, they'll have you sign into an agreement as well too. So anyone who becomes an executive trustee, first of all, they can claim all their out-of-pocket expenses. They're not personally liable for the debt. And third of all, they can charge a fee. And again, that gets into a big issue, which I know if John wants to talk about it. If it's unclear about the fees, you may end up going to court to decide the fees as well.
Well, there is certainly room for court supervision over the fees that an executor charges to administer an estate.
I'm sure there's family members that say he's charging too much or being liberal with expenses, right?
Well, there aren't too many family members who say he's charging too little.
Yes,
so,
that's true.
That's not a problem we run up against too often. But I mean, basically, when the executor is close to finish his or her job, he or she will circulate executors' accounts, which will set out not only what they've spent in administering the estate, but also what their fee is going to be. You know, for an average, typical estate, one often sees something in the area of 2.5 to maybe 3, or maybe a little more than that percent. The legislation does permit a maximum of 5%, but one tends to see that for the more complicated estates. But either the beneficiaries sign off on these accounts and agree to the fee, or they don't. And if they don't, because they dispute the fee, there's room for court supervision, where from time to time I appear in front of the court where we talk about what the fee should be, and the court will make a decision on behalf of the estate.
And if one of the beneficiaries is under the age of 19, you have to, residual beneficiaries, that's whatever's remaining, you have to go to court to get your fees approved, because the guardians don't have the jurisdiction to approve on behalf of a child, and the public guardian trustee does not. So the only people who can approve the accounts, which then means the executor can get paid, is the actual court.
So somebody cannot act on their behalf.
No, we've got an example right now that 80% of the beneficiaries signed off on the accounts, but the other 20% are children under the age of 19. Their parents have agreed to the accounts. The public guardian trustee is not opposed to the accounts. We're hoping that it's going to be a relatively straightforward court application, but we still have to make the effort to go to court to
go through the process
in order for the executor to get their fees approved. So the court's there to make sure nobody tries to take advantage of the situation.
Well, we still have to go through, and we touched on it. John wanted to continue talking about the executor and trustees, but gifts, what you do to convert assets into cash, paying the bills, basic stuff like that, leaving specific gifts or funds to people or societies or charities. So we're going to continue the conversation about your estate and planning and what you need to do to get prepared, the basic rules, but it has to be done properly. I think that's the main theme that we want to touch on today. We're speaking with John Lakes and John White from LakesWhyteLLP in North Vancouver, and we'll continue the conversation next on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.